All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV21-0378, Crossroads Estate Homeowners Association versus Landwehr et al. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes in which to present their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. We have read the case briefs. We have discussed this case, are familiar with the facts. Please bear that in account during your presentation. At this point, counsel, are you ready to proceed?
Yes, Your Honor.
Please do so.
Good morning. I'm Darrell Manhart. I represent the defendants Landwehr. I'd like to reserve at least 4 minutes for rebuttal. I understand I'll watch for that. The burden of showing a covenant, a real property covenant, runs with the land is upon the party asserting the covenant. Here, that burden was on Crossroads Homeowners Association. It was their burden to prove it, not the Landwehr's burden to disprove it. The Superior Court here stated that she relied or considered 3 things in that regard. The CC&Rs, the covenants, conditions, and restrictions, the recorded navigation easement, and a realtor form of contract that was referred to as the HOA addendum. The consideration should have started and stopped with that first item, the CC&Rs. The Crossroads Estate subdivision consisted of 18 lots owned by 4 different parties. The CC&Rs are signed by one party, 40th Street and McClellan, which owned the bulk of the lots but did not own all of them. That's the only party signing it.
Did it own lot 11?
Pardon?
Did it own lot 11?
It did not, Your Honor. It owned lots 1 through 9 and 12 through 17. It did not own lots 10, 11, or 18.
It's very odd to have a group of homes that are generally governed by an HOA and CC&Rs to have lots accepted out. Is there anything odd about this development that would justify that?
Well, Your Honor, I agree that it's odd, but I don't have facts to tell you why that. Certainly, the normal situation I would expect would be a developer or declarant files CC&Rs before it's sold any lots. It states its general plan of how it's going to develop them, and then as it sells them subject to the CC&Rs, and at the end, it's a developer that then ceases to be one of the owners. But I have to agree or state that there's nothing that would prevent a group of disparate landowners to decide they wish to get together and sign CC&Rs and subject their properties to them. It's just not, you're correct, it's not the normal way it's done. And in this situation, you have a document that certainly looks like, has the appearance of what I think Your Honor is describing as something as if the declarant was going to file something setting out a scheme for its lots, and it's only signed by that declarant. But to back to where I guess my starting point was, is the fact that CC&Rs are supposed to be a contract with only the one signatory. There's no other party to that contract. That's not a contract. It could be a contract if the others had signed. If I go into what the Class 1s, 2, and 3 covenants, for Class 1 covenants, which is what this document looks like, the contract doesn't exist until there's a deed referring back to the CC&Rs. And then upon acceptance of that deed, the grantee and the declarant have then formed a contract. Class 2 and Class 3 covenants are different. Class 2 is really irrelevant here, so if there's a question, please ask. But Class 3 covenants are where you have adjoining landowners, 2 or more landowners, decide to subject their properties to restrictions or covenants and restrictions, and they sign the document all together, and that is a contract immediately. Here you have a document that looks like Class 1 covenants, and when I get to some of the language, I think that's what it would have to be. So it's not a contract at all at that time, and it can never be a contract unless there's a formal document signed on behalf of lots 10, 11, and 18, subjecting them to the CC&Rs. And it's conceded here that the Wilmoths, who were then the owner of lot 11, did not sign and never signed the CC&Rs. If you look at the document itself, opposing counsel put together his own appendix. It's I believe, the very first item in his appendix. The first sentence identifies 40th Street and McClellan as the declarant. That's singular. It's the declarant. When you read the rest of the recitals, it talks about the declarant subjecting the property to these covenants, conditions, and restrictions. Well, the only party that's subjecting any property to conditions and restrictions is the declarant. The declarant only owned lots 1 through 9 and 12 through 17. So you don't even have within the document anything that shows the others are subjected. The fourth sentence of the document says the declarant will convey said properties subject to certain protective covenants. It says they're hereinafter set forth. Again, that's a future intent. That looks like Class 1 covenants, which would exist when the declarant transferred lots 1 through 9 or 12 through 17 to somebody else, and they accepted a deed subject to the CC&Rs. It has no effect on lots 10, 11, or 18. It's only when you get into some of the definitions, which is what the Superior Court relied upon, that broadly defines lot to mean any lot on the plat, which is, it says are lots 1 through 19. In fact, the plat does not have a lot 19. It's non-existent. There is a lot next to lot 18 that says not a part, that perhaps at some point in the development of these properties somebody thought there would be 19, but there isn't one. So that doesn't make any of these lots subject to the CC&Rs. The fact that the document was sloppily prepared to refer to additional property that the declarant did not own cannot operate to make those properties be subject to it. So the simple proposition I put forth in our brief is you don't really need to analyze this case any farther than that. Lots 10, 11, and 18 are not subject to the CC&Rs. Now, the Superior Court went on and looked at the avigation easement. The avigation easement was filed contemporaneously with the plat, not the CC&Rs, the plat. They're one digit apart in their recording numbers, filed the same date. The avigation easement is a document that satisfies the statute of frauds. It's signed by all 4 of those owners. It's notarized, it's recorded, but it doesn't say anything about CC&Rs. It has nothing to do with the CC&Rs. The document says it's an easement given to the city of Mesa, the owner of Falcon Field, an airfield, and says that it gives permission for overflights over those properties. The owners are agreeing that planes flying back and forth over their properties have an easement to do so. There's no mention of the CC&Rs at all. They did not exist at that time. The Superior Court, though, used that document and said, well, in the CC&Rs, there's a reference to declarant and developers. And my opposing counsel has correctly pointed out that I was mistaken. The word developer or developers does appear in the CC&Rs in Articles 3 and 4. It's not defined, though. You can't tell who those are from the CC&Rs. The Superior Court said, well, I see the word develop in the avigation easement. I think those are the developers, so that must be the other parties to the CC&Rs. If you look at the avigation easement, the word develop with a small d appears twice. It's with the reference to the capital O, the defined term, owners, which are the 4 owners of the properties. It says the owners plan to develop their property as residential property or for residential purposes. It doesn't define them to be developers. It doesn't refer to the CC&Rs. You can't really use that the way the Superior Court did to now take a later document and say, that's who the developers are. And while that's improper contract construction, I'd also say it's also illogical here, because if you look at that document, then you'd have to, I'm sure, based on the avigation easement, you'd have to say that all 4 of the owners are the developers. So then you go to the CC&Rs where you have a declarant and developers, and it doesn't make any sense to say the declarant is 40th Street and McClellan And the developers are 40th Street and McClellan and the 3 other property owners.
Well, even if it did, wouldn't they have to have signed or given, we'd have some document showing that,
Yes.
that they had delegated their authority to sign on their behalf to someone?
Yes, Your Honor, that's my basic premise is you'd have to have that. The plat doesn't, the plat acknowledges that there's an intent for there to be an association that's going to own the tracks, but it doesn't commit any of the owners to any CC&Rs. It doesn't refer to CC&Rs, it refers to a homeowners association that's eventually to be assigned the tracks, which are the 4 street segments and some landscape elements around those 4 street segments. The other document that the Superior Court judge cites to is the document referred to as the HOA addendum. And that's merely one of the contract documents in the transaction between the Landwehrs and their grantor, Valerie Randall. That document is not an agreement between the owner of Lot 11 and the Crossroads HOA or the other owners of the properties that are recited in the CC&Rs. It's not signed and notarized. It doesn't have a legal description and signatures. It doesn't meet any of the requirements of the statute of frauds for the HOA addendum to somehow a document between my client as a purchaser and their seller. It doesn't meet any of the requirements to subject Lot 11 to the CC&Rs. It's not recorded.
Counsel, if the document had met the requirement for the statute of frauds, would you disagree that a seller could bind a future buyer and say, hey, look, we're not a part of the CC&Rs, but I want to sell my property to you and make you, as part of the purchase agreement, agree to be bound by the CC&Rs? That would not be problematic.
It would, Your Honor. As you've just framed it, it would not be sufficient. For Valerie Randall to have subjected Lot 11 to the CC&R, she would need to sign a document with the other owners.
Why?
Because that's what you're subjecting. It's supposed to be a document that subjects a group of properties.
I could say, as long as I own this property, I don't want to be part of the CC&Rs. But when I sell it, I want my neighbors to get the benefit of full membership in the CC&Rs, or the buyers to get the full membership of the CC&Rs, and agree to have the buyers be bound.
Well,
why is that a problem?
Well, because you're talking about a document between Randall and the Landwehrs. That document, she might have them sign a contract as they agree to subject their property. Someone still has to sign a document as an owner of Lot 11 with the other property owners. Arguably, you might debate me on whether the HOA would be sufficient as the other property, but you can't subject it to the CC&Rs. What she could do is in the deed. So if you want me to make a concession, I'll concede if Valerie Randall had issued a deed saying, I'm deeding you the property subject to the CC&Rs recorded at and put the number down, and they accepted that deed, that's probably sufficient.
Okay.
She didn't do that. Furthermore, this HOA addendum is merely one of the contract documents. That's signed on February 1. And February 20, after Mr. Landwehr's investigated the CC&Rs, they signed a document deleting that HOA addendum. So despite the fact, or in addition to the fact that it doesn't qualify itself under the statute of frauds to subject the property to the CC&Rs, it's really not relevant as a contract document after the actual parties to the contract agreed to delete it from their contract.
So, counsel, if we were to accept your argument, the HOA also argued unjust enrichment. I'd like you to take a moment to address that claim.
Certainly, Your Honor. I did, of course, cover it in my reply brief. Their complaint does not state it's for unjust enrichment. It says it's for breach of contract and lien foreclosure. There is one sentence which does use the words unjust enrichment. That's what they hang that entire argument on. The elements of unjust enrichment, which are, I cited one case with the 4 elements in the brief, there's no pleading of those allegations. They do not plead that. And when you go to the prayer for relief, they don't ask for relief based upon unjust enrichment. They ask for a breach of contract remedy and lien foreclosure based on that. Going further, sort of an appellate procedural argument is the trial judge did not grant relief based on unjust enrichment, only on breach of contract based upon the CC&Rs. Unjust enrichment would be a different remedy. There's no lien on the real property for unjust enrichment. There's merely a monetary award, a damage award. according to their own brief, their damage award would be greater than they say is owed under the assessments that weren't paid. So this is a different form of remedy, and the law on that is you'd have to file a cross appeal if you want different relief. You can, the appellee can argue any basis they want that supports the judgment that was given, as long as it's the same remedy. If they want to expand that in some way, you have to do a cross appeal. They did not. So besides the fact that I argue there is no unjust enrichment argument here, they also would not be entitled to make it in this appeal.
If we agreed with you and vacated the ruling below and sent it back, would they be free then to pursue whatever they've pled, at least in their initial complaint?
Well, that's not in my position is it's not in their initial complaint, and they can't. And also because they have not preserved it with a cross appeal, they can't do that either.
But there wasn't a ruling against them on their below, so what would they have appealed from?
Well, Your Honor, you're effectively treating it as if they have cross-appealed it and that you are remanding it for that to be decided.
No, routinely, if a court grants a relief on some but not all claims below and doesn't affirmatively rule against the claim below, we vacate and send it back, and then litigation can continue with whatever was still pending.
Well, 2 points, one of which I'm repeating one I
What would
made.
they have appealed is the question I'm asking. What ruling could they have appealed on their cross appeal?
They would appeal the fact that the judge did not grant them relief on unjust enrichment. That would be the cross appeal. But if I can make 2 points, one of which I'm repeating is I maintain their complaint does not preserve that, does not make that argument. Secondarily, I put forth in the reply brief, their argument that there's unjust enrichment is based upon this argument that somehow the use of the streets and the gated entry is what entitles they should have got relief for that. The CC&Rs that they rely upon make the common facilities 3 perimeter walls and the landscaping, not the gated entry that is not mentioned, the streets aren't mentioned, and the plat specifically dedicates Tract A, which is all the streets, to the public. They're privately maintained, but dedicated for public use. So there is no unjust enrichment that they claim anyway. So there's nothing to remand on that.
If you win here and then the CC&R or the HOA decides to change the gate codes and not tell your clients the new numbers, are you going to be back here suing?
Yes, Your Honor. And I cited in a footnote a case, it's a common law dedication case as far as its background, but I did cite in a footnote, I think it's Hunt, that referred to something where there was a common law dedication of a road and said that where there was a gate, and the court said something to the effect that as long as there's a gate entry provided to any party that's entitled to use the road, that might be okay. And that's what I would say here is that if they want to put a gate and allow my client to use it, that would be permissible, but they can't put up a gate and then deny my client the ability to use it because the streets are public. Everybody is allowed to use them. They really can't have a gate that keeps anybody out. I'd like to reserve the rest of my time, if I may.
You may.
Thank you.
Counsel, when you're ready.
Thank you, Your Honor. May it please the court, my name is Charles Maxwell, and I represent the plaintiff appellee, the Crossroads Estates Homeowners Association. Before I get into my argument in chief, I would like to respond to Judge Howe's inquiry. Is it odd? It is not only odd that there be a separate lot in a private street gated community, it is unheard of.
Well, because I asked the question because I think it is odd, but just because it's odd doesn't mean that it's improper or illegal.
Well, and that's where we get into the arguments that they failed to address in our brief, Your Honor. There are both legal and equitable servitudes. The entire argument that counsel has raised here is one that has blinders, very small blinders. It ignores the case that the trial court relied upon, Powell v. Washburn. Powell v. Washburn said that that argument that counsel just raised is outdated. We now rely upon the restatement of property servitudes third. And in that case, we look at the totality of the circumstances, and I'll review that as I go through this. They did not touch that because they can't. They can't take their blinders off and secure reversal. The sum and substance of this case is whether the defendants, appellants Leonard Landwehr and Kimberly Landwehr are subject to the recorded CC&Rs as found by the trial court, or alternatively, whether they have been unjustly enriched by the benefits and services provided by the association and which they have undeniably received and continue to receive. The Crossroads Estates is a gated community with private streets. It's landlocked and is only accessible via the gate in private streets. Now, one of the arguments that we just heard, court might go back to their motion for new trial, where they said just because a set of CC&Rs claim to pose restrictions on certain property, they are not binding as a matter of law when the owners did not sign. And yet, that is the very argument that Powell v. Washburn rejected. The Landwehrs have failed and refused to pay any assessments, although they have taken and continue to take full advantage of all the benefits we provide. After significant briefing and oral argument, the trial court went to great detail and effort in issuing its ruling in favor of the association and against the Landwehrs. Rather than dissecting and addressing said ruling in its entirety, the Landwehrs chose to only address a select few findings and conclusions taken out of context. And they did that because to address those would show the weaknesses in their arguments. For example, the seminal case relied upon by the trial court in issuing its ruling is Powell v. Washburn. The trial court relied upon it for the principle that, quote, the hallmark of contract interpretation is to effectuate the intent of the parties and to carry out the purpose for which the CC&Rs were created. As such, the court looks at the language of the contract and the circumstances surrounding its creation, close quote.
Because how can a contract be formed when at least one of the parties doesn't sign any document?
Well, if you look not at the few paragraphs they cited from the court's ruling, but the entire ruling, you'll see that when you read the CC&Rs, it did intend to cover Lot 11.
But did anybody who ever owned Lot 11 sign those CC&Rs?
Yes.
No.
Okay.
Then how do we...
Then where is this contract that you're talking about?
The contract is, if you look at how the court's ruling comes together in Powell v. Washburn, you look at
Did Powell v. Washburn and for CC&Rs that was never signed by an owner of the property?
I believe Powell v. Washburn, citing both Choicer and Fedoroff, and that's a question, I can pull the case and review it real quick, Your Honor, but if you look also at the cases we cited, including Nickerson, Green Valley, and Shalimar Association, there were no such signatures. But they were still enforceable because we have both legal and equitable servitudes.
Do any of those cases help you get around 33401, where it requires every deed or conveyance of real property must be signed by the grantor?
Again, Powell v. Washburn addresses those same issues, and you look at all the documents. And that's why in their briefs...
We're talking about contract interpretation. Real property and contract interpretation are not birds of a feather. There are statutory requirements for transfers of interest in real property that are set forth in Title 33. So how do we overcome the requirements that the legislature said are necessary to convey an interest in property?
Well, we believe those requirements are there, Your Honor, and that Lot 11 is included in that document. Was it a very well-crafted document? Not at all. No one will deny that. But when you look at the totality of the circumstance, everything going on with respect to the plat, with respect to the CC&Rs, the subsequent subdivision report, when you look at the documents that the Vermoos were involved in, they said, we are subdividing and developing this project. Were they geniuses? No. But the documents and the totality of the circumstances...
Did the Vermoos own Lot 11 when they said that?
What's that?
Did the Vermoos own Lot 11 when they said that?
They did.
At the time they set up the CC&Rs, they were the owners of Lot 11.
They were. They were the owners of Lot 11 when the plat was put together. They were the owners of
The
Lot
plat is
11.
a different thing than the
Right, but
CC&Rs.
They signed that, the plat. This is the order, plat avigation agreement. A few months later, the CC&Rs. A few months later, the subdivision report. In those documents, the Vermoose established that Lot 11 was intended to be part of the CC&Rs. Could they have hired an attorney and done it better? Yes, we all know the phrase that you can pay me now or pay me later, but you'll pay me a lot more later. But the court reviewed that, and that is why they did not cite or try to discuss Powell v. Washburn, except for two irrelevant concepts. By completely ignoring the trial court's reasoning under Powell v. Washburn.
Because my review of the record was different. At the time the CC&R was executed, did the Vermoose own Lot 11?
They did.
Okay, and they signed the CC&Rs as the owners of Lot 11?
No, they did not sign the CC&Rs. Lot 11 is referenced in the CC&Rs as being bound by the CC&Rs. Lot 11 is referenced in the CC&Rs as having...
Lot 11 specifically references, or CC&R specifically reference Lot 11?
Absolutely, and that's in our brief, Your Honor. I can pull it up right now if you would like. It's in the definitions portion of lots. Lots is mentioned 63 times, I believe, in the CC&Rs. In fact, the CC&Rs make an exception for one right with respect to Lot 11, and that is they were allowed to have 2 farm animals when all other properties were excluded. And the judge put that specifically in her ruling. She said, Lot 11, unlike lots 18 and 19, that there's a specific paragraph that says those are excluded as they will have their own CC&Rs. But Lot 11 is referenced in there a couple times, and the court said, you can't exclude specific provisions and say that Lot 11 was not intended to be covered. Counsel referenced the fact that there was a document that was outside of the purview of his appeal, where he says that the Landwehrs and Randall tried to exclude themselves from the HOA because they were grandfathered. Now, they were grandfathered only as to farm animals, and the judge specifically addressed that issue.
Can a person develop land, creating an HOA with CC&Rs, and think, it's good for you, it's not good for me, so I'm going to set this up so that all the owners have to abide by the CC&Rs, but since I'm the one that created this, I'm not going to join in. Why couldn't an owner and a developer decide to do that?
Yes, and that could be done very easily, Your Honor. In fact, under both the Condominium Act and the Planned Communities Act, developers can exclude themselves from the obligation to pay assessments. In fact, that is also what the trial court judge referenced. A party could also theoretically exclude themselves in a gated private community if they were one of the original developers from ever paying assessments. They would never get around the obligation to avoid paying for all the benefits they received. So even those cases where you see of private roadways and things like that, and those discussions about those cases, they always have to pay their fair share. So when we get to that unjust enrichment argument...
Let's talk about it. I'm interested in that one. Was that litigated below, and did you include that in your cross appeal?
Thank you, Your Honor. The unjust enrichment argument was completely briefed and argued in the trial court.
Did the trial court rule on that, though?
The court did not rule, and as we know, contrary to the arguments, and many of these arguments were raised for the first time in their reply brief. So I did not have the opportunity to educate the court on that, but I believe it was Judge Morse that did refer to, or it may have been Judge Campbell, sorry if I can't remember. Appellate Rule 13b-2 sets forth different standards with respect to an appellant versus an appellee. An appellant can only appeal those issues that he or she actually identifies, cannot reserve issues for a reply brief. However, an appellee is not subject to the same standard because of the standard of review that applies to me but doesn't apply to him. This court can affirm the judgment for any reason argued below, and no cross appeal is necessary. In fact, the case they cited was outdated, and if you do the shepherdizing on that, you'll see that it actually says, look at Rule 13b-2. this is no longer applicable. So under 13B2, if it was argued and briefed, then this court can issue a ruling in our favor under unjust enrichment. And that law is clear.
I'll say I agree with you to the broad principles, but I don't understand how we could affirm the decision below on the basis of unjust enrichment. Because unjust enrichment would not create servitudes that run with the land, et cetera. Unjust enrichment would be a damages claim. And the damages you seek or sought under unjust enrichment seem to be very different than the ones that were awarded by the trial court below.
Yes and no. This court has broad powers, again, under the standard of reviews that we cited and that they did not distinguish. This court has broad equitable powers to form a remedy that will be applicable in this instance. In this case, this court can say, yes, they are unjustly enriched. How do you calculate unjust enrichment? You usually calculate it based upon the amounts that would have been applicable with respect to a valid arm's length transaction, contract. So in this case, we also look at damages.
So you're saying that the amount of damages or for an unjust enrichment claim haven't been determined yet, and that you expect us to do that?
No, Your Honor, what I think I said is the way you determine an unjust enrichment, it's the same amount as the damages below. Now, with respect to the damages, contrary to what it says in the reply brief, the trial court did not make a ruling on damages, attorney's fees, or costs. Those numbers were stipulated. They were stipulated to by the Landwehrs, and then the court merely affirmed the stipulation. There was no challenge as to those amounts. So when you're looking at these cases, and they did ignore all the cases that we cited 42 authorities, they made mere reference to 7. They couldn't address the other ones because those cases make it clear that they are responsible. Now, when you're looking at damages, you have to remember, too, that the Landwehr's lot is not one of a few equally sized lots in the community. They're about twice the size of all the other lots. Now, I don't know if I answered all your questions on that, but I want to go through this. When we look at the intention issues, in no time have the Landwehrs ever made any attempt to explain why. One, they never made any reference to any discussions with the seller of Lot 11, Valerie Randall, prior to purchasing Lot 11.
I hate to be dense, and I feel like I'm being dense, but you keep talking about the intent. Whose intent are we trying to determine?
We're trying to determine the intent of the Landwehr's predecessors in interest to Lot 11, starting with the Vermoos.
Okay.
Because in their own briefs, they've argued that the Vermoos could bind all subsequent owners. They then argued that the Randall could bind subsequent owners to the property.
And what document is it that the Vermouth signed that bound subsequent owners that we were looking at the intent of?
Well, they signed the plat, they signed the abrogation agreement, they were involved in the entire subdivision report
But
process.
they didn't sign the CC&Rs.
They did
Earlier,
not.
I thought you said that they signed the CC&Rs.
No, I never said that, Your Honor. I said we've agreed that they did not sign it. That's the defect that would not have made this.
And so the document that we're looking at the intent for is the fact they signed a plat that preceded the CC&Rs, right?
Yes,
Okay. And an abrogation agreement that does not reference the CC&Rs.
but is referenced in the CC&R.
Just yes or no. Does it reference the CC&Rs?
No, it does not.
Okay. Is there any document that them or a predecessor signed that says we want to be bound by the CC&Rs?
Yes.
What is that document?
That document, Your Honor, and before I get to that one, in the abrogation agreement, it does identify the Vermoos as the developers of that project. The document that in Appendix E, remember we have all these documents and they are for consideration. Appendix E contains the written and signed acknowledgement of both the Landwehrs, predecessors in interest, stating that Lot 11 is subject to the CC&Rs and subject to assessments. That's Appendix E.
What's the title of that document?
The time of that document is when the Vermoos sold the property to the Landwehrs. The title company, First American, would not allow the escrow to close without that issue being resolved.
But subsequently, that issue was resolved and that addendum was removed from the title package, is my reading of
No,
it.
that's
Am I incorrect?
You are incorrect, Your Honor. So what happened is the Landwehrs, Vermoose and Randall both agreed the property was subject to the CC&Rs and assessments. Randall becomes the owner, and she pays assessments during her period of ownership, and that's Appendix J. And then prior to, then Randall decides to sell the property in 2018.
So you're talking about the first sale from the Vermouths to Randall.
Randall,
That document.
signed by both parties, said Lot 11 is subject to the CC&Rs, membership, and assessments.
Okay. I was thinking you were talking the transaction to the Landwehrs,
No.
but okay.
So now you have, leading up to, you have Appendix M, which is the text messages. The Landwehrs being told, you are part of the HOA, there are assessments, there are transfer fees. You have the affidavit of Randall preceding close of escrow saying that this is subject to the association close of escrow. But when you're looking at the purchase documents, one of the documents the court relied upon was the HOA addendum, as she called it. And that document said, you are part of an HOA, there are assessments, this is the amount, there are transfer fees, review the CC&Rs, know what they are. They signed it, said, yes, we have that. That is a document where they acknowledged this is part of the CC&Rs, and that's why I referred to that one reference in there.
But don't we have to start with the CC&Rs themselves and then have another recorded document that acquiesces in membership there too by the Lot 11 owners, either past or present?
Your Honor, as we cited in our brief, recorded documents, the purpose of recording is to give notice. Recording, it says, is never required when you have actual notice. So recording is to put people that don't have any information on notice. If you have notice, as the case law and authority we cited to you says, recording is irrelevant. Actual notice trumps recording. So yes, they have it, they read it, they said, we read all these things, and during this process of when we first purchased the property before we closed escrow, we came to the conclusion that we were not subject to the CC&Rs. Your Honor, I've practiced HOA law for almost 38 years. You all have heard lots of HOA cases here at the Court of Appeals. If all a person had to do to get out of CC&Rs was to do an addendum to their purchase contract saying, I don't believe I'm subject to the CC&Rs, you would have to have 15 more divisions to handle those cases. So you can't
But
put a little...
counsel, you would agree this is a unique case in that you have 4 separate owners of a tract of land to be subdivided, 3 of which did not sign the CC&Rs. The largest portion of the land was held by the person that developed the CC&Rs and the only person that signed them. So this is kind of not your typical HOA case. Would you agree?
Absolutely.
All right.
So it is not typical, Your Honor, but based upon all the cases that we cited, it is not atypical. This type of situation comes up all the time, and that's why this court does not go with the archaic strict construction approach. For Powell v. Washburn, this court relies upon the restatement of servitude's third property and looks at the totality of all the circumstances, including the documents I just referenced. Now, I know I'm
Out of time.
Yeah,
You are out of time.
Thank you.
One final thought, briefly.
Thank you. It said, Appendix S, that's the deed from Randall to the Landwehrs, states that Lot 11 is subject to the restrictive covenants.
Thank you, counsel.
Thank you.
When you're ready, counsel.
So much to cover, Your Honor. One point, Powell, there are signed CC&Rs. Powell's about constructing the document. It talks about determining the intent of the parties. You don't get to Powell here. The trial judge should cite Powell, but you have a document that's not signed by any other party. There's no intent to determine. The Superior Court minute entry refers to the intent of the CC&Rs as opposed to the intent of the parties because there's only one party. So picking up on Your Honor's comment about the difference between contract law and real estate law, when council talks about notice, an actual notice and constructive notice, that's fine, except there's no contract satisfying the statute of frauds. So notice of a document that if you examine it shows it's not signed by any of the other parties is sufficient. That's the basis. If you look at the cases construing our recording instruments, or the recording system, that's the purpose of it. You have notice of this document, you go look at the document, the determination is that it's not binding on anybody but the declarant, if at all. He doesn't need to investigate further. Furthermore, the documents that he has relied upon here, Appendix E and S, are both in the group of documents the trial judge deemed inadmissible. So I don't agree that they're entitled to be considered, but even if you consider them, they don't establish what he wants. The escrow instruction between the Wormuths and Randall is between them and says that they understand that there's an HOA, but it doesn't satisfy the statute of frauds, and it's also not a document that my client would have seen. So there's no notice of that document. It's a document in a previous escrow. He got that by a subpoena. You know, how is my client or any party that wants to buy Lot 11 supposed to know that? It's not sufficient for that. The deed he refers to in S just has a warranty, a warranty exclusion that says it's, when you grant a deed when you say it's subject to, those are disclaimers or reductions of the warranty of the grantor to the grantee. So when it says subject to encumbrances of record, it doesn't make valid prior recorded documents that were ineffective to begin with. So here you have, again, a document that's only signed by the declarant that they're trying to bootstrap in to have it be applicable to everybody else. I'm not going to have time, I see, to cover a whole bunch of other points. So, you know, and I want to point out, though, that by the request here, you should not remand this on the unjust enrichment. If you look at the prayer for relief in their complaint, they did not ask for that kind of relief at all. So the fact that they inserted it in an effect to avoid, an attempt to avoid summary judgment, and here in their appeal, where I don't agree that it's preserved for appeal, doesn't entitle them to remand on that. We request that you reverse the summary judgment that's presently in place, instead remand it with directions to enter summary judgment for the Landwehrs and award them attorney's fees. Thank you.
Thank you, counsel. Thank you both for your arguments here today. We will take this matter under advisement and issue a written ruling in due course.